Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Tonight, I have with me a special guest. Actually, you saw him just a second ago, but we have two special guests. One is my good friend Stephen Burch, who is an intellectual property attorney practicing out of Florida. If you have any IP questions, I can help get you into contact with him. And the other is another good friend of mine, Diversity and Comics. So welcome to the stream, guys.
Thank you. Hey, good to be
Thanks.
back.
Yeah. Thanks for inviting me on.
Yeah, no problem. And that was it was a last minute surprise for you guys there. Diversity in Comics will be with us for a little while, but it is getting a little late, so he may have to buzz out before the show ends. But welcome to all of you in the chat. Tonight we're going to be talking about a couple different issues, and here's the order we're going to do them in. I think I have the Texas Citizens Participation Act listed first, but we're going to do that second. We're not going to involve Mr. Meyer in any questions about his ongoing litigation. Out of professional courtesy to him, we will do all of our speculation and discussion on your boy Zack's lawsuit after he is long asleep. First, though, we're going to talk about some different events that are not related to that lawsuit that have been going on with his YouTube channel. Some of you may know he received a couple copyright strikes in the past 24 hours. Just exactly what you want on Thanksgiving Day is to have to worry about your YouTube channel. So, two things. One, you can participate in this conversation very simply and easily by sending a super chat through YouTube, or, and this is what I would prefer, you can click on the Justice Chat link in the description, and that will allow you to send a chat through PayPal. It gives you more characters for the same amount of money, and it doesn't give YouTube any money, which is something that I much prefer because they are really pissing me off lately. So with that, I'm gonna ask Zack over there to tell me kind of what's been going on with the if you can explain to me and the audience, I guess, what's happened over the past 24 hours with your channel Diversity in Comics.
Okay, so basically, have you ever seen those bicycles where they have 2 or 3 seats?
Yeah, the tandem bikes.
Yeah, so this bicycle had 3 seats, and it was me, it was Mags Visaggio, and it was Kwanzaa Osai Gieffo, and we were riding through Central Park, and everything was great. And then we had some ice cream sundaes, we rode on the carousel, and then I went back, and then I saw that I had gotten 2 copyright strikes, and I was like, what the hell is going on? And it was because I wanted to be in the front and steer. That's basically So seriously, what happened is I run a YouTube channel. Kwanzaa and Mags have various issues with me. I have issues with them, but they're kind of lighter. They're kind of like I always swear, no matter how many stupid things people try against me, that if we met in real life, it'd just be like, oh, hey, what's up? Hey, and then just chill. But they seem to hold things very close, and they did copyright strikes against me. Now, I've had copyright strikes before, but they've been these kind of automated ones. Some random company in East Germany will say, your review of Gods of Egypt was our copyright, but don't worry, we'll just take all your money.
Yep.
So those are these weird soft ones where they'll say, hey, don't worry, you're not in trouble. Just all of your advertising money is going to go to these weirdos who are doing a false claim. And then you respond and you go, this is fair use. And also, who are these people? It's always like Hoffmann-Strop GmbH. It's like, no, you guys don't have the rights to Gods of Egypt. But this was a, quote, real one. These were the first time I got real ones. And these ones look pretty serious because when you go to respond it, instead of just being a blank form, it basically says, you are now beginning legal proceedings. And it says by countering this, you're basically challenging their claim. Now, the claim is vague. It just says, copyright claim. Like, it doesn't even describe it in any way. It doesn't say, was this a fair use issue? Was this a counterfeit issue? Was this, whatever. So at first I was kind of like scared. I was like, oh man, what is this? And then I talked to some people and they go, no, this is the standard thing. The deal is that it basically triggers something that they have to respond in 10 days, basically showing YouTube that they have a lawyer and they're proceeding to defend it, or it's just, they're just wasting everyone's time and it gets dropped. So it was for two different reviews. One was for one I did a couple days ago that got a good response. It was lighthearted fun and mainly an art critique. The other one is from 6 months ago, and that's where the real maliciousness comes from, because Kwanzaa and Megs know each other, and it's kind of a long inside baseball story, but there's a small but fervent group of people who are obsessed with me. And not in the Mean Girls way where, why are you so obsessed with me? But like, they're literally obsessed. 10, 12, 18 hours a day for 6 months talking about me, Ethan, and Comicsgate. Mostly me, maybe like 60-40 me and Ethan. So as soon as I saw the hit from Kwanzaa, I said, I know what's going to happen. As soon as he sees that goes through, he's contacting Mags and all his friends, and he's going to say to report. Now, luckily, again, this is kind of, internet history, but I had deleted almost every video about Mags from over the last year during the summer. Basically, what happened is, I got about a year into my channel, and I realized something's up. Like, this isn't just like jousting on the internet. Like, these people are legitimately obsessed with me. Like, the idea, back from the Marines, that someone would be like, man, I'm so pissed. They're like, what are you pissed? It's like, so-and-so said this. It's like, man, that's effed up, dude. He goes, when did he say it? 13 months ago. It's like, what? Like, did you guys fight or did you squash it? How are you still angry about? I have wounds, physical wounds I'm not angry about 13 months later. So I saw this obsession and I go, I'm out, dude. I'm out. So I apologized. I deleted the video. I thought it was done. That was totally the wrong thing. Never apologize to someone obsessed with you. It just makes them more angry.
Let me stop you right there. Never apologize. Never do it.
Never.
Yeah. That's like the most lawyerly, non-legal advice we could both give you.
Yeah.
Never apologize.
100% agreement. Never apologize.
So I didn't think through it or talk to a lawyer. I was just thinking, like, as a person, it's like, hey, you are so far past normal right now. And I don't know what I had involved with this, but I'm just going to say sorry and like walk away. Absolutely did not work in any way, shape, or form. So the Kwanzaa one was filed, and then basically what it looks to me like is that Mag scoured 1,300 videos and couldn't find any about her. But there was one from 6 months ago where I did a comic book hangout. Basically, I just flipped through a comic. I'll talk about it for 5 minutes, but it's mainly so you're not staring at my lap. And then I just answer questions just like you're doing right now. So it was so desperate and malicious to find one video that had some copywritten material in it. And it was, fair use, but it was just, in my opinion, a malicious misuse of the reporting feature. And this has been a standard of these types of people to misuse reporting features. I had a GoFundMe for reason X, and that endured dozens of false reports. So That's basically what I had. I was going to wait to do the counterclaim. I talked to some people who have done it, and they go, no, they try to scare you, but it's not as big of a deal as it sounds. So I did a counterclaim. I did the same thing for both. I said, this is fair use. This, like all my videos, is meant to educate and entertain through parody, satire, critique, analysis, and subjective opinion. So that's what I submitted about an hour or so ago.
Very nice. Now, Stephen, could you shed some light on this for us? Copyright claims and DMCA claims are different things. They're different parts of the same machine, but they are separate issues. Could you explain the difference between a DMCA takedown request and an actual copyright claim?
Yeah, the DMCA requests are a step below a copyright claim. So a copyright claim involves filing a lawsuit. It involves lawyers. it involves a lot. The DMCA claims are much easier. They usually involve just filling out some online form and attesting to things that you may or may not actually be true, and based on what the statute has set up, the DMCA statute, service providers like YouTube or Facebook or whatever are obliged to follow. So it's a copyright claim is a big deal. It's a lawsuit. It involves a lot. A DMCA claim involves filling out an online form. So there's a bigger standard between the two.
Now, my understanding, and correct me if I'm wrong on this, is that a DMCA claim is basically a tool for platforms. It's kind of a covering the bases for platforms. So once you file a DMCA claim, the platform is obligated to take down if they find anything even remotely close to infringing material, they automatically take it down. They give you an opportunity to respond. Once you respond, they give the original filer up to 14 days to produce court papers saying that there's an underlying copyright claim that is now being pursued in the courts. If they do not, they are obligated by law to put the content back up. Is that correct?
Kind of. I mean, the DMCA is set up and rightfully so, a kind of a neutral system where YouTube shouldn't be responsible for copyright disputes between parties, and so there's a notice, and if YouTube complies with that notice, they'll take it down, and the person who's been taken down has a certain amount of time, I forget off the top of my head, to respond. And if they respond, YouTube can put it back up. But as long as they comply with that, YouTube's not responsible, and it's not legally responsible for the content on its site. And so it doesn't matter to YouTube whether or not someone's filed a lawsuit or not. It just needs to comply with the statute so that it's not legally responsible, and the two parties that are disputing can go to court or not go to court. But it's not is the important part for YouTube.
Right. So when you guys see these things, when you see a DMCA takedown, the interesting part about them, though, and this is something that Zack mentioned earlier, is that they are legal proceedings, and that means that what you do. And I apologize for not having a pop filter. I'll try and say all of my plosive syllables away from the microphone. But what you need to do is you need to make very sure that what you're doing is done in good faith and with a reasonable belief that what you're doing is true, because you are initiating a legal proceeding, and those the statements that you make and the assertions that you put forward are done under oath and under penalty of perjury. So if you are falsely claiming a DMCA takedown, like say you're claiming something that is not your work. For example, one of the videos that Zack is talking about is from 6 months ago, so we don't know exactly what content there was in the video. However, the artist in question, Mags Visaggio, is not only an independent writer, but also is a writer for DC, a backup writer for DC Comics, and the copyright depending on the comic in question. Now, I think the general consensus is that it's probably one of her books, but it's possible that she asserted, we'll make a hypothetical, if she were to assert a copyright claim over the DC comics, that would be a false DMCA claim, because she does not actually own the copyright to a DC comic that she happened to have a writing credit on. DC would own that, and it would be up to DC Comics to file a DMCA takedown, not up to Mags. So unfortunately...
Well, that's interesting, and that actually reminded me of something that happened a while ago, I think in the summertime. is actually, it might even been maybe like a year ago, but Captain Cummings, who used to do a lot of comic book reviews, he did a comic book for a review of Marvel Iron Fist, which they've always owned. And the writer artist of the storyline, if I remember correctly, put up a copyright strike against him because you get to see your accuser. It's actually you were talking about, it's kind of an interesting, transparent prospect, or what is it?
Process.
Sorry, it's like process. Thank you. Is that
that'll be
the accuser has to identify themselves. Although Kwanzaa didn't put his name, he just put All Black LLC, which is kind of easy to guess that was him. But Max just put her name, and Carr Andrews apparently put his name. That's how Captain Cummings knew about it. But I'm not sure if he contested that or just let it drop. I was honestly going to I was thinking about letting the first one drop. But then when the second one, it just really hammers out the maliciousness of it. I don't think either one of these have the false claim of, they don't own the property, but the falseness and maliciousness comes in the way that they use a legitimate and important process. With Kwanzaa, besides just personal animosity, I think he was extremely embarrassed at the horrifically low quality of the book in question. This book looks like it was drawn in 2 days.
I took a look at it. And I'm not an art at all, but man, that is some low tier work, we'll say.
So I think he was embarrassed, and I think he was. This was the reason. With Mags, it was just pure personal animosity and maliciousness. They want to take down my channel. They openly talk about this. They tried this tactic this month, this tactic the next month. So this is this month's tactic.
So Stephen, if I may ask, what kind of process is involved in combating these sort of things? Like, let's say hypothetically, you have a client come up to you and he says, hey, I've had these false DMCA takedowns on my channel. I know they're false because what I do is I do commentary or reviews of movies or music or whatever. And the false takedown came in and I want to fight that false takedown. What is involved in that process? Oh, you're muted, buddy. Your mic got turned off.
Can you hear me?
There you go.
Ah, crap.
Yes.
No, you're back. You're back now.
Okay.
Yeah.
So I think the most important thing to note is that when you sign off on a DMCA takedown claim, you're asserting and you're signing off, your digital signature that you've evaluated fair use, you've evaluated all these things, and in good faith, you believe that this is a copyright infringement claim. And if they haven't, and that's what what you're describing is people, it's not a copyright issue. It's people, they just don't like you. And they're using this DMCA process, this takedown process to get you. There is in the DMCA takedown statute an entire subsection devoted towards combating this type of thing. And so you can assert a claim and you're entitled to your damages, you're entitled to your attorney's fees, your costs for these takedown procedures. I mean, I guess the next step, in terms of steps, the next step, unfortunately, is talking to an attorney, and no one likes that. But I mean, that is the next step, is you talk to an attorney and this is actionable.
So what happened was, this kind of veers into the subject I don't want to talk about, but
stay away from that.
But since I've started my channel, I've had enemies that have been trying to take it down. And my standard thing to do is when something gets hit, even if I can fight it, I say, what are the similar videos to this? What are other things that can get hit? Because those 3 strikes, they can all come in the same day. They usually don't, but there's no reason they can't come all in the same hour, and then your channel's done. So I've typically deleted things because I say the risk versus reward tells me to delete this. Now, when I got this, I just had a phone and everything was kind of hard to do. And so I deleted videos that were similar because I said, oh, well, they can hit me 3 more times and then I'm completely nuked. But the thing is, I just deleted some content that was making me money. And I did it because someone filed, in my opinion, a malicious DMCA specifically to hurt me, not because of a legitimate feeling. Another thing, if you haven't seen my videos, and it sounds like you probably haven't, it would be the most frustrating way to pirate a book to watch my videos. I talk about stamps or my friend's dog for 5 minutes. It's on a cell phone where usually you can't see the entire page at one time. It jiggles around. I don't have a pop filter. Sometimes when my battery dies and the video just ends suddenly. It's like, did you ever see pirated videos? I'm sure none of us did because none of us would do this.
God forbid, no.
But back in the 90s, it was like watching Mystery Science Theater 3000 because somebody would be in the 8th row and then you would watch someone stand up and go get popcorn and come back with the popcorn. But that was like a Criterion Blu-ray DVD compared to watching my videos. It would literally drive you insane trying to, quote, pirate copywritten material by watching my videos. And I always make sure to leave off, a couple of pages. I literally say, skip this one for the copyright gods, so I can't get a strike. So there's ample good faith and due diligence on my side to respect copyright. And in my opinion, on the other side, at some point, it's just people just are not very intelligent. And they say, I'm going to take down his channel by filing these because I own the copyright. And you're telling me something I actually didn't know, that there's a protection for the falsely accused or malicious misuse of the reporting function.
Right, and that's what Congress put into the DMCA takedown notice is if people are going to maliciously use it, you have a right, and like you said, you've lost money. I mean, and YouTube, people who make money off YouTube or anything off the internet, that's where they make their money, and to be able to just send an email essentially and take you down for no reason at all. The Congress has provided a remedy for that. And again, you're correct. I haven't seen any of the videos. I don't know the details. But
Racist pilot. I mean, goodness gracious.
I am. Can you not tell? I'm white and bald. The most racist of the. I'm drinking Budweiser right now.
Oh my goodness!
It's Thanksgiving. I made it till late.
But so here's the remedy on a false DMCA claim, just so we're all clear on this. And of course, this would be Zack, something that you would want to talk to a lawyer who is licensed to practice intellectual property law and who is in your state probably, and who has developed an attorney-client relationship with you, which neither of us have. The most we can advise you to do is to eventually review this with an attorney if you're considering pursuing it. But what I can tell you is that in a false DMCA claim, the remedy under the statute is your actual damages, so that's actual money lost due to the false DMCA claim, and then the other damage would be any costs or attorney's fees. So how this would work, basically, in a hypothetical suit to counter a false DMCA claim would be you would go to an attorney, you would put down a retainer, you would pursue the false DMCA action. It would probably get very quickly settled in something like this, or you would have to go through, to a trial, and they would do a fair use analysis and all of that stuff. But in the event that you win, part of what you would recover would be your attorney's fees, any actual attorney's fees that are billed to you, or reasonably would be billed to you in the course of the action. So it's a neat way to allow people to do it. However, there is sort of a barrier to entry for your average person, because you still need to typically pay an attorney up front unless you have access to an attorney who would waive that, which most of us don't, because we're blood-sucking vampires, let's be honest.
I do need my money.
Yeah.
Alcohol.
Yeah. And for real, pay your attorney now. No.
Most important bill you have.
Yeah, but you happen to be uniquely situated to talk to an attorney who you have a relationship with, probably without, or just kind of in the course of your normal business. And so, what my personal advice would be to run these things by him, see what he thinks. Because if I'm not mistaken, he is actually he does practice in copyright and entertainment sort of stuff, and so he probably is well aware of anything that we would be saying, and he's the one you'd want to take any sort of advice from on how to proceed in regard to that. But
yeah, absolutely. So do you want me to tell the story of the most delicious part of this story?
Yes, please do.
So this is where it just gets. So I left Twitter, I don't know, like a month or so ago, a couple weeks ago. Just because of various reasons related to doxing and stalking and people stalking people that were donating to my GoFundMe. And I basically told people I don't want to hear about Twitter, but they still send me screenshots and things. And the two people who filed copyright claims against me have spent a good portion of the last week or so gleefully commenting, I believe, sharing and retweeting and liking, wait for it, drum roll, a pirated version of my graphic novel. And I don't mean like this guy released dozens of pages and a perfect screenshot that can be perfectly legibly read.
Now, how did they get the copy of the graphic novel?
I believe everything leads me to believe that it was someone who bought it to roast it, which is absolutely fine. That's a legitimate reason to buy it.
Yep.
I bought books just to roast them. But who then very maliciously did two things. Number one, released, to the best of my knowledge, the majority of the book in completely legible form. Number two, since the pages are not numbered, kind of maliciously implied that he had, doubly maliciously implied that this was the actual story, which makes it obviously it look disjointed. And then, you can kind of cherry pick things to kind of steer it in one direction. So the two people from the reports I'm getting and the screenshots I've seen who are uber concerned about copyright law had no problem with a pirated and maliciously edited version of my book. And I mean, yucking it up for a week straight.
Yeah, and it's important to note the most nefarious and malicious part of this is that these people aren't funny. They're humorless husks. So their roasts and their gleeful celebration over stuff, it all feels like it's like your uncle who you always suspected to be a creep telling a dirty joke about a minor. That's how these degenerates come across. And can I call them degenerates? I think that's their proper name.
I agree.
They're just not funny. So like they're calling, they're roasting you and dunking on you on Twitter or whatever, and as it turns out, of course, none of these people can sustain anyone's attention either in writing or on Twitter, and certainly not on video, because they're just not charismatic or interesting or funny people. So,
well, that's one of the things that I bring up because, these, I'm sure you've endured hits or people plotting to take you down, but why don't they start their own YouTube channels? I have a couple theories about that, which I'll share right now. Number one, that there's something severely wrong with a lot of these people, that if you heard their voice, it would just be very, monotone, dead, and you'd be like, what's wrong with this guy? Number two, several of these people are in fact the same person. So you can't invite, XYZ, these 5 different accounts because 2 of them are the same guy. And the other one is that they live in constant, just as we get attacked by them, they attack each other. It's very easy to get on the outs with these people. So they can't give any kind of controversial opinion or really any opinion at all besides just saying everything is great. One of the biggest reasons for that I started the channel and that there are other similar channels, I believe, started theirs is because criticism basically disappeared for about 10 years. You would have reviews, but they were all glowing. Everything was 8 out of 10, 4 out of 5 stars. And it was a way to get in good with the companies to get hired with them. So there are people who were reviewers and now they're writers because, company X said, oh, you always like our stuff. And then you start writing. One of the reasons that these pros are so thin-skinned is they had a good 10 years of basically getting no actual criticism. So now when they get criticism, it might legitimately to these people feel like some sort of assault, but they don't commit to the bit and they'll roast me for a week straight, which is great. Go ahead, do it for 3 weeks straight. But you got to have some consistency or it just seems like you do whatever is convenient for you at any one time.
Yeah, I'm being told that Mags has a YouTube channel. And I'm just going to take a peek at, let's see. Because, when you look at some people's YouTube channels, sometimes you find things that make them look like perverts. Who was that? Mags has 17 subscribers, 1 video. Good job. Solidly done. That video has a 43% up to downvote ratio. So, I guess Mags.
What's the video on?
It's the trailer Quantum Teens Are Go 1 year ago.
Oh, maybe that was the copywritten material that I was reviewing in the
I don't know.
Hangout that sheet DMCA to oblivion.
It's got 400 views on it. So I think whatever you did was probably boosting. I have a question for you, and this isn't related to anything at all. But let's say that there's someone out there with a pretty significant following who's not your followers, right? Like, let's say this person has about 50,000 followers on a non-YouTube platform, maybe Instagram or whatever. And they threaten to spread your YouTube channel to more viewers. Would that be like a threat to you, or would you thank that person? What would happen in that situation? It's kind of a weird hypothetical, I know.
There were so many hypotheticals, I literally have no idea what you're talking about.
Well, there's someone who doesn't like you very much, who's been watching a lot of your videos and said they were very anxious to share your videos to a broader audience. So I thought that was a little interesting because,
one of the things I kind of know what you're talking about is one of the interesting things about talking is that you're going to talk about all types of things and these malicious actors. And honestly, at some point, I just wonder what's wrong with them because there's more interesting things to do in life. I've done 1,400 plus videos and the average of 15 minutes of speaking. And the stuff that they bring up that they are pretending to be offended by might equal 15 minutes. And this is 15 minutes out of 500 hours.
Right.
Now, so one of their big things is, oh, you said this. And I go, what is the average human's offense rate, per 1,000 hours of speaking? Am I above or below? Is this something egregious to society? Or is this what the average person would do if they recorded 500 hours of just speaking off the top of their head? Not only, in my opinion, does it not make me look bad, but it probably shows that I have some pretty good judgment and have a very, very low rate of being offensive. that leads to the next question is are you really offended if you're combing through year-old videos just to find something offended by, or do you have some weird kind of crush on me? I mean, I'm, saying the simplest theory right there.
The answer is yes to both of those.
Exactly.
But I will say that personally, I hope to have much more offensive content per hour than you do. I want people to be angry and reviled. I don't know. Last night I did a couple hours on female genital mutilation. I've interviewed pedophiles on my stream and stuff like that. So I want people offended. When did we stop wanting to offend people? Because how do we get things to change without a little bit of uncomfortable language, right? Like that's.
So
that's how
I have
happens.
this thing that I say that's actually would probably get me nuked, but I'll just leave a blank and I'll let you fill in the blank.
I was like, oh, good.
And
So
it
you'll say
is
it here. Fine. Thank you.
So what I say is, as soon as we weren't allowed to tell people to stop acting like blanks, they really started acting like blanks. You used to get checked. You used to, kind of go off the ranch and people would say, what? And they would curse you out or something like that. Now you can't basically get anyone's attention. And that's one of the reasons of being offensive is to get someone's attention. It can be tongue in cheek. It can be black humor. It can be blue humor, whatever it is. But sometimes you go, oh, geez, I didn't realiase it till you put that in that really salty way.
I got to stop you there. African-American humor, please. Now go on.
Which African-American humor is a classic example of black humor, no pun intended. They are going to roast you down to the little things floating inside the cells in your DNA. Like the little helix is going to crack at some point. You're going to get roasted so hard. And it's really, really good for letting you know when you're acting weird. Now, when you can't tell someone when they're acting weird or strange, everyone gets really weird and strange because, it's totally normal for me to talk about one subject 18 hours a day for 6 months. No, it's not. And you're acting like a total blank, but I can't say it because that'll get everything, nuked. But you need to have people talk. And part of have people talk is letting them relax and speak their mind. And part of that, a very small percentage of it, a micro percentage of it, is people saying something offensive. Now, you have that friend that's offensive and they don't care for whatever reason. They're never afraid to be offensive. What percentage of their total speech is actually offensive?
Almost none. I mean, honestly, it's almost none. No matter who it is. Even if you're like best friends with Tom Green, that guy's only offensive a tiny fragment of the time. The most offensive comedians are only offensive a small fragment. Now, they may be differently offensive to different people at different times, but because there is no universal offense, right? I'm sure we could come up with something if we tried, but generally speaking,
I could be universally offensive.
we're gonna go on Stream Me and we'll challenge you to do that. We'll see how many people we can ruin. But
by the way, speaking of Stream Me, everyone's been recommending that I get on Stream Me, except for I don't do live streams anymore. But then they say you should also get on BitChute. The problem with BitChute is they picked the worst name in the history of naming everything because it looks to me like BitChute. Yeah. I don't want to be on BitChute.
Yeah, they also they just got defunded by PayPal. So honestly, they're probably on the way out. I don't know how they're going to recover. They don't have a payment processor at the current time. And so it's kind of up in the air as to the future of that platform. So far, however, Stream Me is still going strong, and we can all be the lovable Nazis over there. And being a lovable Nazi is good. If you want to,
what happens? What happens in the future where literally, God, this sounds like a what is that show? BBC, Black Mirror, Dark Mirror.
Yeah, Black.
Yeah.
What happens in a future where 4 corporations get to decide what you get to say?
Yeah, right now it's literally 2. And
Jesus.
I don't know if anybody, I talk about this a lot, but I don't know, some of the people watching might not watch all of my streams. How dare you? I'm just kidding. I stream way too much. But listen, it's Visa and MasterCard right now. That's who really runs speech. It's not YouTube. It's not Twitter. It's not anybody. All of these companies are literally in fear of being cut off at the source of money. I was talking to another lawyer the other day, and he said something very profound and wise, and it was, everyone gets into business. Was this you, Burch? I don't know.
If it was profound and wise, it was probably me.
Yeah, I'll give you credit for it. It was either you or it might have been Keon. I don't remember.
No, I'm way better than Keon.
Well, I agree. But it was everyone goes into business assuming that their customers will be able to give them money. Like, right? Like, that's not even a factor of consideration. It's, will people be willing to give me money? You know, how do I make a product that people want to buy? How do I get that product to them? How do I arrange delivery? The question that never enters a small business owner's mind, at least not in my experience, is, will people be allowed to pay me? And this is crazy because that's where we are today with BitChute.
So this really just popped up within about the last 3 months. Can this be challenged? Can you say literally, like, maybe there's not even a law for it yet? Can you challenge this in court?
Currently, no. Alex Jones has sued PayPal. However, they had PayPal has an arbitration clause, and so Alex Jones has voluntarily dismissed his lawsuit against PayPal, and they're going through arbitration.
And he's going to lose.
He's going to lose, and
I don't know how to do the SpongeBob meme in real life, but they're a private corporation, and it's sadly what's going to win out today, at least now.
Right now, what's interesting is it wasn't always this way, but how the court has really acted in regards to private corporations for the last 50 to 60 years is that private corporations' private property rights supersede every other right. I mean, every other right. Think about this. Private corporations can ban guns on the premises, right? But keeping and bearing arms is a fundamental right that you have under the Constitution. But if you're on a private property, they can remove that fundamental right with merely a sign. Same thing with free speech, free association, practice of religion, all of those things, all of these deeply held rights that we have are subservient to the rights of private property. Now, what's interesting is you have a bunch of people like me probably 3 years ago, maybe a little longer, but 3 to 4 years ago, I would have been the guy defending these corporate private entities and their private property rights. However, we've got so many people out there just saying, well, there's no freedom from consequences for your speech. There's no freedom from consequences from you carrying a gun on private property. There's no freedom of anything. And these companies like Twitter and YouTube and Facebook, they own the entirety of the internet when you really start to think about it. Facebook is the #1 news source on the planet. It's not the New York Times. It's not the LA Times. It's not AP. It's not Reuters. It's not Fox. It's Facebook. The overwhelming majority of people on the earth get their news from Facebook. Facebook has more users than I think any website out there. Twitter is not even close, if I understand correctly. But Twitter is another huge platform, and these companies have claimed a private property right to their servers. However, all of that stuff is on typically government or public funded infrastructure. And so, but we've ignored that, and we've just determined that their private rights supersede any other rights that we would hold. And that's crazy. It's crazy. And I don't know how to deprogram people fast enough, because people that I agree with and like will say, well, they're a private company. They should be able to do and say whatever they want because they're private. And there's merit to that. But when they start infringing on our fundamental rights, I think we need to start really looking at how much, because whenever rights come into conflict, it's technically a balancing test, right? Like the woman's right to privacy versus a baby's right to live is how they decided abortion. And they said, up until, this is Roe versus Wade, up until 28 weeks, the woman's right to privacy supersedes a baby's right to live. Then at 28 weeks, it shifts. And the baby's right to live supersedes a woman's right to privacy. What's weird is that in every balancing test, in every single one, where a private business, not a private person, but a private business's rights has come up against an individual right, the business wins except for gay wedding cakes. Like, that's it.
And what's funny is we've added extra legislation, Section 230, to provide them extra protections to be more free from the consequences of their action. It makes no sense.
Yeah.
So speaking of the balancing thing, that brings up a couple of interesting things that I've noticed. So right now I'm doing the comic book thing full time, but I typically work cybersecurity gigs. So, you get taught about hackers and, foreign governments and things like that. But one of the biggest things is that everything is based off of risk versus reward. So that hacker, he's risking jail time. He's also risking wasted time. So he's not making money. Or, if it's government sponsored, he's, he can end up in literally in a camp, if he's trying to break into some server he can't get into. But one of the things we found with the use of malicious reporting, and I've endured this on everything, Twitter, Facebook, everything, is that we've given a new power to the subway pants shitter. By that, I mean someone who is either crazy or has severe personality disorders and is willing to spend 10, 12, 18 hours a day endlessly finding things to take out of context, endlessly reporting in every way, shape, or form that they can do, hoping that, because a lot of these companies, that report comes down to one guy. The day shift guy says, oh, this is a crank. I get this guy all the time. The night shift says, oh, this guy has ties to white nationalism. Let's knock him out. No evidence, nothing. The other thing related to that, when you talk about balancing is, and it happened a couple of years ago when DC backed out of it was really stupid, just a real short version. Batgirl was in peril on a cover, and people said that was rape.
Yeah, I saw that. I remember that controversy.
So one person spent, I don't know, an afternoon or so really dialing down how many people, because you can make things look like a big hubbub on the internet. And what this person eventually found, it was something really small, like 26 people. 26 people were able to get a corporation to make a really weird decision. Oh, this female hero is in jeopardy. We got to cancel that book. How many times have you seen Batman with like a noose around his neck about to get dropped in lava on the cover of a Batman comic? Hundreds of times.
Not enough.
So
one more time.
That was 4 years ago. About 26 people got a corporation to make a weird decision, and they're not even offended. They're just pretending to be offended. Right now, it can be two right. People who don't like you, who are living off the state or living off their significant other or whatever. They're shitting in their pants all night, and then the library opens and they got 12 hours on a computer. 2 people can take you down if they get lucky.
Yeah, and so what's interesting about this is this is not new, so to speak. There's a podcast I recommend all the time, even though the podcaster is a total cuckbag, but I love him anyway. His name is what's his name? Oh my gosh, I'm gonna think of it in a little bit. Malcolm Gladwell. Oh. Do you have a podcast, Birch?
No, I don't.
You should. No, it's Malcolm Gladwell, and his podcast is Revisionist History. And if you don't listen to any of it, that's fine. but listen to his episode on the McDonald's French fry, because McDonald's used to use beef fat in their French fry fryers. They use beef tallow as opposed to the vegetable oils that they use now. And then this guy came out so hard against trans fats. And he was just a guy. And he was a rich guy. And he personally spent like $15 million fighting against trans fats. And that's why today everybody uses vegetable oils. No one uses trans fats anymore, right? No one uses beef tallow to fry anything. But he talks about how much better the French fries were, and how this one guy completely changed an entire nation's understanding of what a French fry should taste like. And if you think about it, and this is 1993, I think. So if you were born after 1993, or if you were like under 5 in 1993, you've probably never had a legitimate McDonald's French fry in your life. And for that, I apologize to you. I'm sorry. What you have now is a sad replacement that's vegetable oil. But it was one guy. One guy did the entire trans fat scare of the 90s into the 2000s that changed everything. I mean, it changed Kentucky Fried. Like every fast food chain you've heard of was using animal fats and switched to vegetable fats. All of them. Your potato chips have changed. They're different. If you had a potato chip now and a potato chip in the 80s, they're completely different chips because they were fried in vegetable fats versus animal fats. And in many ways, they're probably worse for you. But it was based on one guy using bad studies that he funded himself. It's crazy. However, what's different between now and then is back then you needed to have $15 million to run an advertising campaign. Now you can be a basement dweller going to a public library to sit there for their entire open hours and sit on Twitter and be a Twitter warrior and achieve the same effect. And I think that's what you're talking about, Zach, is that we've allowed these people so much power, and all they have are these tiny numbers but loud voices on Twitter, and it's crazy. By the way, there are a couple chats that are specifically to you, Zach. So I want to read through these real quick, if you'll let me. Before you have to go, I want to make sure that the ones that are addressed to you get spoken to you. So the first one is from Ben Cheevers. He says, love you, Diversity in Comics. Been watching since you had 700 subs because I was searching for videos on diversity and comics and found you. Bought Jawbreakers. Heartbroken about the strikes. I'm psyched about Mark Waid getting taken down a peg. He's such a cretin. Taylor Ray, I think this one is for me. He says, hey, loving the goatee. Keep it up. It's either for me or my thumbnail of Mark Waid. And then
you are looking sexy.
Thank you. I gotta shave off the neck stuff. I can't wait to get.
No, don't do that.
No, just from like back here down. We'll keep the beard going. Taylor Ray also says copyrights suck. Anyway, drink up, buddy. Then Church of Failure says, hey, Rackets, can I get a little attorney church privilege? I got to figure out why these humans get so ass mad over comics. And that is in reference to the anti-Comicsgate people. And that's a difference that Ethan Van Sciver has pointed out over and over and over again, is that some of us are just having fun. And comics are supposed to be fun. It's superheroes in capes saving the day. It is metaphor, it is symbolism, and it's distilled down into its purest, like good versus evil type stuff. Now, sometimes there's nuanced storytelling, but the goal of all of this was just to have fun. And that is gone from some of these people. I think that's what the Church of Failure is getting at. So Fug Off a Tron says, Mr. Meyer, you got me back into comics. They know me at my local comic shop, and it feels good to have that again. Thank you. Never give up. Never surrender. Comics should be good asks Zach, can I get a scrolling down some more? I don't know. Is that from your channel? Is that a frequently quoted thing from your videos, Meyer?
Yeah, I haven't done live streams in a long time, but the thing is, I used to start with a little 5 minutes of a comic book review, which is probably what Mags reported, 5 minutes out of a 1 hour and 47 minutes in the video. But I would never be caught up. I would spend an hour and a half trying to get caught up. So I would just say scrolling down, trying to skip some stuff. So that's why all my live streams were an hour and 47 minutes, because I would start off 10 minutes behind and never catch up.
Yep, sometimes that's how it goes. Watermelon Platypus says, "We'll always be fans, Zach. They can't strike down the loyalty of your audience. They didn't create you, so they can't destroy you." And then,
so this is a really good point. So one of the things that these, I like subway pants shitters. I think that's a good term, and I'm trying to make it catch on.
I like it.
One of these subway pants shitters, like they first of all, they fight for things that are not monetized. They fight to own Twitter. Congratulations, you own Twitter. How much money did you make off of it on your 18 hours a day? But sorry, I lost my train of thought. It's like 1 a.m. here.
No, I gotcha. The chat was that they can't strike down the loyalty of your audience.
Well, yeah. So the thing is that there are other. I mean, at one point, I mean, I've sold 10,000 books. Is that I have everyone's email. Like I can just send. I could even stop doing YouTube and probably continue, on, and then something else will pop up. Somebody's going to figure out how to do a PayPal that isn't PayPal that won't shut you down, and it just comes straight out of your bank. What are they going to do? Contact every single bank and say, don't allow new PayPal to take money out? Like
you really don't want to know the answer to that, in all honesty. So I'm gonna let it slide.
No. You've already figured out how to stop that from happening?
Like I said, man, it's Visa and MasterCard right now pulling the strings on these things. And we can prove it because what was it? I think it was Patreon let slip that MasterCard basically said they had to shut down an individual person's Patreon or MasterCard would stop processing all of Patreon's payments.
Really?
Yeah, it was Jihad Watch.
How is that not tortious interference?
Because there's no requirement to use MasterCard services. There's no right to it under the current law. Like bank transactions.
And no one challenged it.
No one has. Why would PayPal challenge it with their payment processor? With their.
Well, the guy they just cut off all their money to has no money to challenge it.
Right. And this is the thing that I brought up the other day was, how do you fight this if you can't pay your lawyer because you can't write a check?
Yeah. Exactly. It's a joke, but it's
not
at all.
Not to talk about the thing I don't want to talk about, but I've been very, very lucky. Very lucky.
Yeah.
To have people to help me out. But yeah, that's the deal. They count on the expensive lawyer and people having regular jobs and regular lives, and I don't have this, $10,000, $20,000 for retainer. I don't have this money to pay for them every month for the new billable hours. Like they count on stuff like that. So I did hear about one thing, and this is probably your wheelhouse before I go.
Sure.
I'm not into video games, but people were saying this sounds like something similar that happened. There was a channel that they'd roast video games. And then this company put a DMCA, and I guess a couple of YouTubers had a couple of fundraisers for this guy.
Oh, you're talking about H3H3.
Was it H3H3? Because I thought his was, he did a video on this, like a pickup artist type of guy. And then that guy sued him. This was about video games. So I've never heard this story. This might be a second story. That's something to investigate, but multiple people brought it up to me today.
Okay. Yeah, I don't know. I'll have to look into it. If anyone knows what that is, DM me and I'll be happy to cover kind of that case.
One of the people gave a little detail that'll narrow it down. They said it was a company that was known for ripping off popular games, and they do their cheapo version of it.
Oh, this is Grimoire, the Grimoire lawsuit. Yeah, I've seen a couple things about it. I know one guy's been kind of covering it, or not the Grimoire lawsuit, but the Grimoire copyright issue. And like some guy's been basically they allege that he plagiarized a lot of the code. It's like a first-person dungeon crawler, like old school 90s style. pixel art and all that stuff.
Awesome.
Yeah, actually the game does look kind of fun. It's like, I might want to pick that up. But I've seen that, and he like threatened a defamation lawsuit, and he threatened a bunch of other stuff. I don't know if it's the same thing, but that's kind of what it sounds like from what you're telling me. Yeah, Sid Alpha, Lady Wizard just said in the chat, Sid Alpha is the guy who's been talking about it. So that might be it. And then someone else is saying Digital Homicide versus Jim Sterling. I don't know about that.
Okay, I got to dip out. Sorry about that. But thanks for having me on.
No, thanks, buddy, and good luck. And one last thing before you leave. People in the chat have been telling me the whole time to let you know that your fans are behind you, however you want to proceed, man. So thanks for joining the stream.
I really appreciate that, because I feel that stuff like it. People tell me not to talk about this stuff because they're like, it's giving a victory to those guys. This stuff gets me down sometimes. Sometimes it gets me really down. Like I'm embattled. And it's not like when I was in the Marines, everyone is, sometimes I'm just this dude in a room or in a car. So when people, send me the emails, when, obviously when they donate money, like it really, because this stuff is bigger than me. I'm not getting that. Ethan's made some good analogies. He goes, I don't want to describe it that much. Basically, the stuff that's being done to me can be done to anyone else.
Yep.
And it's very easy to do this stuff. So there is a need to push back legally above board, and I got in a unique position where I can afford to do that. So I'm very, very grateful to people who give money or people who say stuff like they just said, because this stuff is intense. Like it's intense and it's constant.
Hey man, you got two people here on the call who deal with guys in your situation all the time. No, there is no good lawsuit to be in.
None.
It's stressful. So we know what you're going through, you do what you need to do to keep yourself healthy and to keep yourself going. And
good
again,
luck.
Thanks.
As I will always say, and I'm sure that Burch will back me up on this, listen to the guy that you're paying thousands of dollars to for advice, because before you listen to anybody else. Don't listen to me. Don't listen to Stephen Burch. Don't listen to the chat. Like ultimately, you're paying a guy thousands and thousands of dollars for advice. That's the guy you should be listening to. That's the guy who knows your case better than anybody else, and all of your advice should go through that guy.
Definitely.
I'll disagree. You should look on Google, and Google should way better than your attorney every time.
What about just guessing? I see a lot of people just guessing.
Works too. Guessing in Google way better than your attorney.
Well, and the final superseding authority to all of this is Jamal Eigel, Esquire.
Well, of course. Yeah, if you got him, I mean.
All right, get out of here, buddy. We want to talk about your case now, so leave.
All right. Thanks a lot.
Later,
Bye.
man. Have a good night. So that was your boy Zack. Thanks for hanging out and allowing us to talk to him. I'm very grateful he was able to come on for a little bit. Jesse N is the final super chat that we have before we jump into this next issue. And I'll ask Mr. Burch for some final thoughts on copyright stuff. But and I want to talk about some stuff that I didn't want to talk about while Zack was on the air with you as well. And then we'll jump into the Texas Civil Protection or Citizens Participation Act, which is the next motion coming in that lawsuit. But first, Jesse N says seed-based veggie oil is poison. And there's actually a lot to that. When those are exposed to high heat, they change into something, and I'm far too inebriated to remember what it's called, but it is arguably worse for you than anything that a trans fat will do. Okay, so Mr. Burch, this is like what? Wouldn't this be your dream client? This guy has a GoFundMe specifically for legal issues. It is $100,000 strong right now.
Jesus.
Isn't he like perfectly positioned to take the fight on like false DMCA claims straight to these idiots and make them pay? Like
100%. I mean, The biggest problem you have with these kind of claims is, well, who has the money and you're not going to collect.
Yep.
But he is, everything he said so far, it's a textbook claim. I would love to represent someone like him.
What you mean? You mean someone with a bunch of people to help pay his legal fees in advance already?
Mainly the money part, but the legal claim part too. He really has a good legal claim,
right? Because like DMCA, people think it's a joke. This has been my thing learning over the past years. All these people think all of this stuff is a game, that playing with people's income is a game, and that nothing can happen. Like Mark Waid, which we're going to talk about in a little bit, the Mark Waid lawsuit. If you'll hang around with me, I don't know if you're familiar with the Texas Citizens Participation Act, but it's basically an anti-SLAPP. And
okay.
And so I think you'll be able to comment plenty on it. But Mark Waid, he thought this was pretend, that he was a white knight, Don Quixote jousting at windmills, and then suddenly he realized that, oh my God, I messed with someone's money, and now they're mad at me. I mean, how could they be? Because I'm protecting women and minorities. How could someone be mad at me for trying to take away their income? But that's the stuff that you and I see, that other people don't, is what happens when you go after people with money, you go after their source of income. They get greatly incensed because they have to keep up that level of income, right? Like it's different if you're broke. If you're broke and you lose your minimum wage job and you have to go on welfare for a while and then get another minimum wage job. I mean, don't get me wrong. Damaging, it's painful, it sucks. But if you've worked and you've built up some sort of career and you're making significant money, you're well into the six figures, and then someone cuts that off, you can't. Most people who have six-figure incomes can't sustain being unemployed. Like it's exceptionally damaging. I don't know how much employment stuff you've had to deal with, but that's what I see.
But I think you're hitting the nail on the head there. Is for quite a while people could do this with impunity. I mean, the people who they were damaging didn't have the means to fight back. But where we're at now, you've got people making a lot of money on YouTube. They're making a lot of money from the internet. And now people are still doing the same sort of bullshit, bull crap.
Don't have to have an excuse.
These claims that have no merit. But now they've got people, they're attacking people who have the means and who are looking at a lot of damages, a lot of, loss from these claims, and they're going to fight back. They can't not fight back, and I think the law as we've seen it, the case law is going to start favoring them because no one's fought back before, and I think people are going to start fighting back.
Yeah, that's one thing to kind of keep in mind on all this stuff is this is new for the courts. And they're faced with, this is something we were talking about before the stream started. I was talking with Stephen, and the kind of controlling case on a false DMCA claim actually comes from Universal Music Group, Universal Music Group.
Right.
And it was in regards to a Prince song. A woman saw her toddler dancing to a Prince song. She pulled out her phone. She started recording. And Universal had these bots and algorithms to go through. And actually, YouTube has gone ahead and streamlined this process for certain creators. They can get on their creator content ID plus or whatever program. And YouTube's bots will comb through this and look for these sort of things, and they'll claim it. Zack talked about this earlier, that some random company will claim all your ad money. They claim a portion of your ad money, and that portion's like 95%. Even if it's only a 5-second clip out of a multi-hour video, they'll claim 95% of your ad money at the onset, and then you have to appeal it and go through the process. Universal was doing this prior to YouTube having bots that existed. And Universal did this to this Prince song that this little girl was dancing to. Now, this woman was represented pro bono by the Electronic Frontier Foundation, who typically is pretty good about online privacy rights and stuff like that, and online freedom. But they sued, and they found out that Universal didn't do a fair use analysis. Basically, if Universal came across any video with anything even approaching content that they could claim as copyrighted, they would automatically file a copyright takedown request. They didn't analyze whether or not the person was authorized to use it. Now, because she had pro bono representation, she was able to fight this and then win. She ultimately won against Universal. Sort of. Yeah. Do you want to explain that ruling a little bit?
Yeah. I mean, the ruling was you can't just send out these takedown notices, but if you want any sort of recompense, if you want to, sue, get back your damages, you have to show some sort of bad faith. And unfortunately, these bots, the court held there was no bad faith there. But what's changed is it's went from these, mega corporation bots to these individuals who are actually, sending these takedowns in bad faith. But that was the big takeaway, is there has to be some sort of bad faith in these takedown claims.
Right, and now we're in this new era where we've gone from these automated bots, like in Universal, to angry justice takedowns, right? Like that's what these people are doing. They're sitting there with their masturbatory ideas about justice, and they're saying, haha, we've taken down the racist video with our claim, and it doesn't matter if the claim is right. All that matters is we took down the dragon. We killed the dragon with our cool internet swords or whatever. That's the bad faith. The court hasn't really dealt with this in an appreciable level at the appellate level yet. They may have dealt with this in district court, and we wouldn't really know. But it's ripe. These cases are ripe for people with means. YouTubers, some of these YouTubers make a lot of money. Like, I can't even imagine what someone with 1 million subscribers makes. Someone like a Keemstar with 2 million subscribers, they make a lot. They make a lot of money. They hold a lot of influence. And if someone were to cut off someone like Keemstar's income, it would be a very, very big deal and a pretty big lawsuit. And it would be ripe for really testing where the system is, where the judges are, and what we can educate and convince judges on this stuff. But even someone like Zack is uniquely positioned because he has a war chest of $100,000 specifically for legal fees that have been given to him. He's uniquely positioned to fight this stuff. I don't know if he will. He'll have to talk to Daniel Byrne. He'll have to decide if it's worth it. One thing I want to talk about that I didn't want to talk about while Zack was here is, and Burch, you can comment on this and let me know what you think. One of the guys who did the takedown request, Kwanzaa, All Black LLC. Oh, and by the way, I checked, and neither Mags Visaggio or All Black LLC actually have any registered copyrights. So they're certainly not going to pursue an action in court for a YouTube video that shows briefly their things. Guys, if you don't understand you might not know, if you don't register a copyright, you're not entitled to statutory damages. You're only statutory damages on a copyright claim are up to $150,000 per claim. That's a statutory damage. To get that, you have to actually register your copyright with the Copyright Office, which is a filing fee and all of that stuff within a certain amount of time of the creation. I think
3 months.
3 months, yeah.
Yeah. You got 3 months to do it. Otherwise, you got to prove actual damages.
Right, and actual damages on someone showing your garbage comic book on stream, even if they went through every single page, you got a $2 comic book. How many sales did you lose? Like 4? These people don't sell comic books. This isn't 50 Shades of Grey. This isn't selling 100 million copies. These people are selling less than 1,000 copies. So their actual damages are something like, a couple $100, maybe. This is what we have to understand. Mags and Kwanzaa, they can't sustain a claim. That they couldn't sustain an actual copyright claim. It wouldn't be worth it for them. A DMCA is a cheap way to take it down. But anyway, Zack is uniquely positioned to go after them. And as people who do own intellectual property, I think it'd be pretty interesting for Zack to win and settle by winning their IPs. Man, that would be great, wouldn't it?
Oh yeah.
Burch, do you know? Have you ever had a court enforce a judgment by granting access to an IP? Like, is that something that is what is it, leviable or whatever?
I have not. I mean, I guess in theory it is. It usually comes down to money, and that's where the court ends up. I've never had anyone, try to just hand over some sort of intellectual property. I guess that's more of a bankruptcy court issue, but it's never been something I've dealt with.
I would pay so much money to see someone try and force a levy or a garnishment on existing intellectual property. God, that'd be funny.
Oh, it would be great. Off the top, I mean, you pay attention to the Maddox issue. I mean, I would love it. It just seems, but in my head, there's a lot of steps that have to happen before it gets to the fun part.
Yeah, absolutely. Because they'd go through real property first. But
exactly.
Guys, think about how funny this is. Like, these people, you could honestly levy their cars, not their primary vehicle, but if they have two, if they're like a family and they have 2 cars, you could take a car from them.
Right.
You could take a boat, a camper, any of these things that are non-essential, jewelry. You can levy this property. You can force them to make an accounting of every valuable thing they own and take it. Oh my God!
You could literally take their pants. It's
their pants. And if you don't think like a drawer full of pants has significant value, you haven't properly talked to an insurance agent. Picture what you could do to these people, and the problem is the reason no one does it is because it's expensive to get there. But if you've got money that you can throw away to make a statement, oh my goodness, you can really ruin someone. Taking all of their suits, for example. Like, what do you do if your job requires a suit and someone takes them in a judgment? Oh man, that's funny. Okay, so Landon Mack and James says, agreed, Nick. I'm 21, live in a paid-off house with a government job, making money, and all I do is save. The job is toxic and constantly tries to fire people. If they fire me, I'm effed. It's frustrating. Yeah, most people live at their comfortable level of income, and any adjustments to that income have a lag period where it's very hard to adjust. That's why you have savings, because if you take a pay cut or a payment entirely lose your pay, you have to have savings to buffer that out. as you have time to adjust your lifestyle. This is one thing I made a big point about Meyer versus Waid, is that Waid has been probably relatively stable in his income for a long time and is probably living at that level of income, whereas Meyer just received a huge infusion from Jawbreakers of several $100,000, and now he's got a $100,000 war chest. You know, he's not living off of that. He hasn't adjusted to that level of income yet. So he's kind of uniquely situated to take on a legal case where Waid is going to really be feeling the pinch. 2 super chats, and then I want to move to the TCPA, because this is kind of interesting to me. Where Tiger Ray says, do you think it would be profitable to open up a law firm that specializes in false DMCA claims? I mean, I'm sure there are some. Well, if you're going to do false...
Here's the problem.
Yeah, go ahead.
You've got to collect, and it takes nothing to file. It literally is an online form to file a DMCA takedown. And you've got to be able to collect money. And there are lots of good ideas, and they're great ideas, and they're right ideas. But if people don't have money, it's not profitable. And I just don't see how you have an entire firm based off of false DMCA claims when it takes nothing to make a DMCA claim.
Right. And the other thing is, if you're doing DMCA claims, you may as well be doing copyright anyway. Like, if you're already in that world and you're practicing in that area, the logical follow-up for a DMCA claim is, when you find a defendant with money, is to go after the full copyright claim. Like, that's where you're going to make money. You're not going to make a ton of money on the DMCA claim. There may be some like legal services firm that'll do the DMCA claims, but they probably aggregate other simple claims as well.
So I have a lot of clients who I do DMCA claims for, and the reality is, the vast majority of what we're doing those claims for are people who are offshore. They're, Russian, they're Eastern European. You're never going to collect against them. And that's what the DMCA is helpful for on the good side. When you're making a valid claim, it is against these people who are just mirroring your site or scraping your content, but you're never going to get money against them. Never.
Right. Yeah. If the people are overseas, you're definitely not collecting, because how are you going to haul them into court? They'll just ignore it. If they don't come to America all the time, there's no way you're getting their assets. Ryan English says, what kind of penalties should there be for false DMCA claims like this? There's one penalty I wanted to talk to you about, Stephen, and that is there's a criminal penalty for perjury, but I have to imagine that the criminal penalty for perjury is basically like most perjury stuff involved in court proceedings. It's got to be almost never enforced, right?
Exactly. Yeah, you'll never get that. It's hard enough to get a false DMCA claim in general. Perjury is, judges are never going to want to do that. They're going to want to encourage testimony. They're going to want to encourage people to talk candidly to the court. You're never going to get a perjury claim, and never.
Yeah, the way you get a perjury claim on one of these things is if you're doing a DMCA claim against like a county attorney or something. Like, you're going against someone who's got the means to not unethically by any stretch of the word. No attorney or police officer would unethically make a charge based on a personal vendetta, but that's who you have to go after. A politician, an attorney, some sort of police officer, someone who has the power or connections to the power to bring charges. But there's one final thing I want to talk about on this DMCA thing, and I was going to bring it up earlier, but I got sidetracked. So as you know, Meyer, Diversity in Comics, is in a current lawsuit against Mark Waid, right? Kwanzaa, one of the guys who filed the false claim, actually was just hired by Mark Waid, like just before filing that claim. Does that open in your mind, like as we enter into hypotheticals, does that open any interesting channels there?
I guess I'm missing the point of the question. Who hired who?
Okay, so Mark Waid is currently in a lawsuit against Richard Meyer, right? The guy who was just on the show. So Mark Waid just hired one of the people, probably maybe a couple weeks ago, who did a false DMCA against Richard Meyer. Does that impute any bad faith on Mark Waid? Does it add discoverability? Does it make an interesting deposition?
Oh, hell yeah. I would love to point that out. Could you imagine the cross-examination of someone like that? That's what makes an attorney's heart grow bigger, like that kind of stuff. Yes, 100%. That is very discoverable, very important, very relevant to any legal proceeding.
Yeah, so suddenly any conversations that they may have had concerning, the plaintiff become discoverable. That's pretty interesting, because you have to know if he hired this person for the purpose of attacking the plaintiff. It sure looks like it. You could assert bad faith motivations in doing the DMCA claim. I wonder if you could impute. I don't know. Do you know anything about like imputing a DMCA bad faith on a third party? That seems weird. But what if like in a hypothetical, what if Waid were to hire this guy and he said, "Look, I'm going to hire you. I want you to do this DMCA claim, and I know it might not be legit, but I want you to do it because we're trying to take him down." You wouldn't be able to transfer the DMCA claim to the other party, but you just argue general, like you just go after general bad faith, right? Like how would that translate?
I mean that just goes to the heart of the matter. I mean, you've got someone who is untrustworthy, and if you get it in front of a jury, I mean, how fun would that be to point out and to let them know? I mean, here's someone who lies for fun and who lies for profit or motive, or I mean, it's a very, very relevant topic. I would enjoy cross-examining someone like that.
Yeah, me too. And
it's never that easy. I never get stuff that fun, but if I did,
it's because we're not blessed with opposing parties and counsel who are maybe I can't blame it on the counsel, but opposing parties who are this dumb.
No,
this has been just baffling, and I think people might be spoiled if they watch my shows enough. If you've been following the Maddox thing, to get a Maddox as your opposing
I did
party.
get a Maddox. That was fun. That was easy. That was the easiest thing I've done in my entire career.
Right, you did on the one issue, but like to get a Maddox paired up with a Landau is like you can't roll that dice. To get a giant puffy man baby like Mark Waid, who just can't keep from shooting himself in the foot. It's like having a Maddox. Like these types of parties, normally you're dealing with reasonable, somewhat people who maybe like, they're otherwise reasonable. Maybe they're deluded in this action or something like that. You're not dealing with these enigmatic idiots who are just hell bent on ruining their own chances. And so like when we see these things, or when I see them, and I assume when you do, and guys like Keon and Josh do as well, it's like, why can't we get these people?
I never get that lucky. Yeah. I would love to put them on the stand. It'd be so much fun.
Yeah. Okay, so I've got one chat here, and then we'll move into the TCPA thing because some people might be interested in that. That is the next motion that is coming from Waid/Zaid in the Diversity in Comics lawsuit. They alluded to it. They've asked for an extension of time to file their TCPA claim. So I'm going to talk about the TCPA. It's basically anti-SLAPP and what it means and what their TCPA claim is going to look like and what I think the chances are. Blue Samurai Zero said YouTube needs a consequence mechanism for users who report copyright falsely. Just looked on Twitter. They're grossly obsessed with diversity in comics and Comicsgate. Excuse me. Found iron sight scans. Listened to over a year of DNC vids, or listened to over a year old DNC vids tonight, and he said back then he lives in Austin. Well, I mean, yeah, the whole idea that Mark Waid, I just didn't know Texas was involved in this. That's not going to hold up.
No,
at all. It's a very bad case to try and do that. I mean, it's their job, their attorney's job to try and get it dismissed on jurisdictional grounds if they can. But
that's never a winning argument. I've won lots of jurisdictional arguments. Every state thinks it has jurisdiction over literally every person in the world. That's you're arguing up the wrong tree if you think you've got a jurisdictional argument, especially after the stupid crap I've seen from him about it.
Yeah, and the whole idea is not that he necessarily specifically knew they were in Texas. It's that he directed the activity to Texas. Well, in this case, by contacting a Texas corporation about a Texas contract involving two parties that both reside in Texas, whether he knows they're in Texas or not, he's directing the activity with intent to Texas. You don't get to just say, well, I didn't know they were in Texas, so that doesn't matter. Like, all of his activity is directed into the forum, whether he knows it specifically or not. He, one, should have known because he's dialing a Texas phone number. The corporation has San Antonio, Texas listed as their thing. The other person has routinely talked about how they're in Austin, Texas. He should have known reasonably. But the other thing is, like, the intent of his activity is not, you know what, I'm going to specifically contact Texas and ruin a Texas thing. No, you are contacting people about a Texas thing with intent. That's the difference. Go ahead.
Oh, no, I was about to say, he should be expected to be hailed into Texas court based off of his actions.
Because he should be expecting to be hailed into whatever forum he's directing his actions into. It doesn't have to specifically be the forum that he'll be hailed into. He has to know that if I call up someone and make a defamatory statement about someone else, I have to be expected to be hailed into the forum where I'm making the defamatory statement. So that's how that goes. So the jurisdictional argument is going to be out. We're going to get to the TCPA.
He's going to lose on that.
and at every loss, I'm going to get out my. I don't even know how to say it. Like, I'm going to buy some tiki torches and claim it to be a Charlottesville victory or something just to make him mad. Like, I don't even care about Charlottesville. I don't care about any of this stuff, but I'm going to figure out some way to stomp on the corpse of their argument because that'll be funnier to me. Tillip says, happy Thanksgiving, man. Happy Thanksgiving back to you, buddy. And then Darking D says, I promise, Your Honor, I didn't know I was being a tard in your backyard. Exactly. So on to the Texas Citizens Participation Act. This is what's called an anti-SLAPP statute. It's Texas versions of it. A SLAPP statute protects against strategic lawsuits against public participation. That's SLAPP, okay? And this is what happens when someone is suing someone else to silence their otherwise protected activity. In specific, it's about speech, okay? So let's say you don't like what someone is saying. You might file some sort of claim against them, like a copyright claim. You might file a defamation claim just because you don't like what they're saying. You ignore the merits of what they're saying, but you've got money and you want to force them to pay a bunch of money to defend their actions. That's a SLAPP lawsuit. All right. So then several states have implemented a way for you to go ahead and challenge a SLAPP lawsuit prior to going through most of it. It's a pre-trial. It's actually a very pre-discovery motion to strike down, to dismiss the lawsuit. And you say, no, this is my protected right. Typically, it's a First Amendment right. This is my protected right to go ahead and make these statements, and this person is trying to silence that right. So I'm going to dismiss this motion, and if you win on a SLAPP statute, specifically in Texas, you get your costs and attorney's fees back. Now, a very prominent Texas Citizens Participation Act lawsuit was just won very recently, and it was Donald Trump versus Stephanie Clifford, a.k.a. Stormy Daniels. Stormy Daniels sued Donald Trump for defamation when he made some statements about her in regards to her statements about an alleged threatener. I guess that's someone who is allegedly hired to come and intimidate her to not disclose some details about Donald Trump. She
needs a malpractice attorney is what she needs.
She really does. Michael Avenatti. Stephanie, strike while the iron's hot. That guy is losing everything right now. Get a malpractice attorney on him immediately. You're guaranteed to win that one. But anyway, so she claimed that someone came up and intimidated her and her daughter, and then Donald Trump came out and said this was all a lie. It was absolutely fake. So she sued him for defaming her by saying that this was a lie. All right? Donald Trump motioned to dismiss on Texas Citizens Participation Act grounds. He won, and now they're fighting over attorney's fees. I think he's asked for something like $350,000 in attorney's fees.
Seems appropriate for some sort of pleadings motion.
Right, a pre-discovery pleadings motion, which probably took maybe 4 hours of work.
That's how I value myself.
Yeah. So we actually have a judge's opinion to kind of go off of to see how this works. But let me talk real quick about the TCPA, and I'm going to read from the statute. Okay, so the purpose. This is Texas. What is it called? Civil Practice and Remedies Code, Title 2, Chapter 27. Actions involving the exercise of certain constitutional rights. All right. So Section 27.002, the purpose of this chapter is to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, and at the same time protect the rights of a person to file meritorious lawsuits for demonstrable industry. Now, what follows is that if a legal action is based on, relates to, or is in response to a party's exercise of the right to free speech, right to petition, or right of association, that party may file a motion to dismiss the legal action. A motion to dismiss a legal action under this section must be filed not later than the 60th day, blah, blah, procedure. Boring. There could be a hearing. Here's the important part, the ruling. The court must rule on a motion under Section 27.003 not later than the 30th day following the date of the hearing on the motion, except as provided by subsection C, the motion of a party under Section 27.003. A court shall dismiss a legal action against the moving party. So that would be, in this case, that will be Mark Waid moving to dismiss the action against Richard Meyer. All right. So court shall dismiss a legal action against Mark Waid if Mark Waid shows by a preponderance of the evidence that the legal action is based on, relates to, or is in response to the party's exercise of 1, the right of free speech, 2, the right to petition, or 3, the right of association. Now we can rule out 2 immediately. 2 involves government matters exclusively. The right to petition is all relating to government. This is not a government issue. So we've got the right to free speech or the right to free association. The statute defines free association as a communication between individuals who join together to collectively express, promote, pursue, or defend common interests. I don't think that's going to apply in a tortious interference case where one person calls another person and says, your boy Zack is bad. He called someone a cum dumpster. He has to go. That's not really a right of free association to me. I don't know if you disagree with that, Mr. Burch, and feel free to disagree with anything that I say here and challenge it. But in my personal opinion, the right of free association, it says individuals who join together to collectively express, promote, pursue, or defend common interests. That would be people assembling together, forming a group, maybe an organization to petition and challenge something. So I don't think that applies. What might apply is the exercise of the right of free speech, which is it's a communication made in connection with a matter of public concern. Now, a matter of public concern, and I apologize for going through this, guys, but this is how we as attorneys have to go through these statutes to figure out if you have a claim or not and how we're going to argue that claim. So matter of public concern is defined in the statute, and it says it includes an issue related to A, health or safety. So we know that one's out. B, environmental, economic, or community well-being. It might be argued that the economic well-being, we can argue potentially community well-being. C, the government. That's out. D, public official or public figure. You could argue potentially that Meyer is a public figure or at least a limited public figure in the comic book industry. So that's a possibility. Or E, a good product or service in the marketplace. I kind of wanted to get your input on this one because that in the marketplace is weird because at current time, the product they're discussing is not actually in the marketplace physically. You can order it. However, it is not out. So what do you think about a pre-order book on Indiegogo?
You know,
or actually, no, it's not even a pre-order book. It's a contract that has been created but not fulfilled. Sorry, go ahead.
But it's close. I mean, prior to, and you talked about the female genital mutilation the other day, yesterday actually. Prior to that, anything in my mind, involved interstate commerce, and the idea that you were almost in commerce implicates interstate commerce, and I think that meets that definition. I mean, it's not necessarily interstate commerce by definition, but you have people who are trying to buy this product, and I think that in my mind hits the statute.
Okay, so we'll take it. That's fine. We can say this is about a product in the marketplace. So we have a couple different things that they'll have to argue against. However, they might be losing arguments, and that's okay. All right. So they're going to have to argue against the idea that Meyer is a public figure or at least a limited public figure. They're going to have to argue against the idea that this is about economic or community health because Mark Waid will say, of course, this is about the economic health of Anarctic Press. This is about the community health of the comic book publishing community. And so I was merely looking out for those concerns. That will be the arguments they will make there. And then finally, he'll say that this is about a product that is about to enter the marketplace, and as far as legally, it is ostensibly within the marketplace because you can go and purchase it. You could go and purchase a copy of Jawbreaker's Lost Souls on the Indiegogo campaign, and the product that was about to be released through Anarctic Press would be very quickly entering the marketplace. So what happens next? They're going to assert these things. They can make good faith assertions that this would be considered under the TCPA. The next part is this. So once they establish that this implicates the right to free speech, we go to the next section here. The court may not dismiss a legal action under this section if the party bringing the legal action establishes by clear and specific evidence a prima facie case for each essential element of the claim in question. All right, so we've got two claims in question. One is tortious interference. So we know that there has to be knowledge of the contract, an intent to interfere with the contract, a communication that does indeed interfere with the contract, and then damages involved stemming from the interference of the contract. So we know Mark Waid talked about the deal between your boy Zack and Antarctic Press. So he clearly had knowledge that there was a relationship. I think that is a prima facie case, at least, since he said, Antarctic Press is going to publish Jawbreakers. I'm going to call them. We have prima facie evidence that he knew a claim or a contract existed. 2, intending to interfere with the contract. I'm going to call Antarctic Press and tell them about who they're dealing with because I don't think they know about it. That's a prima facie case, at least, for intent. I think these are pretty much nails in the coffin on those two issues. 3, actual interference. That'll be up to your boy Zack. That'll be up to him to produce some evidence of actual interference. I think we have evidence of it, at least to make a prima facie case based on Mark Waid's statements, based on the fact that the contract was breached. We know the contract was breached, and we know that the contract was breached after Mark Waid's call. Now, he says in his interview with Bleeding Cool that he didn't encourage him to do it. Of course he says that, right? And Antarctic Press initially made a Twitter post that seemed to indicate that they did do it in response to pressure from Mark Waid, and then they came out with a counter-indicative post on Twitter, and then they came out with another counter-indicative post of that on Twitter. So there's some weird stuff there. But I think we are at the point where a judge has to say, look, a jury needs to determine whether or not there was an actual breach of contract that is related to the tortious interference. I think they've got a prima facie case there. But it's possible that Zack has more evidence that we don't have access to on Twitter, and we'll have to see. And then finally, damages. There's prima facie damages. That's no problem. He had a contract deal. He no longer has a publishing deal, and he no longer has a publishing deal with a 50-50 split on any books sold. So we know there are damages that are involved. He also had to create an imprint because of it and do all this other work. So damages are prima facie quantifiable. The real one is that third element. Can he show a prima facie case? If he can, then it moves on to the next part of the test. And that's notwithstanding the provisions of subsection C, the court shall dismiss a legal action against Mark Waid if Mark Waid establishes by a preponderance of the evidence each essential element of a valid defense to the non-movant's claim. Now, there aren't valid defenses other than the valid defense to tortious interference. The affirmative defense you would assert would be justification. Justification would be if Mark Waid was a shareholder or stakeholder in AP, contacting AP, or if AP had contacted him first to ask for his recommendation as an insider to the industry, they could then say, he could say, I was merely responding to their request. They have a right to ask me about this stuff because I'm qualified to talk about it as a publisher, blah, 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 blah. He could assert some sort of privilege there. To my knowledge, no privilege exists. No legal justification exists. His only defense is a truth defense, which I have gone through in another video. And truth is not a defense to tortious interference in Texas as far as the current case law stands. So I don't think he passes Section D on the tortious interference. And then we go through the same test basically on how it plays out with the defamation claim. Now, I think the defamation claim I've always thought the defamation claim is a little bit weaker than the tortious interference claim. However, the defamation claim got a little bit stronger when we found out that he made the defamatory statement specifically in Texas. So that's my personal take on it. I don't know. Oh, I lost Stephen Burch. He might have had to go. Just a second. Let me see if he's still around. I was just about to ask Stephen if he had any opinions on this, but he buzzed out. So, anyway, he might be gone for the night, guys. I'm waiting to hear back from him, and we'll see. But basically, how the tortious interference or the defamation claim would work out would be the same way. We'd go through the elements of defamation. Is it a false statement made to a third party, causes damage, and can that damage be fixed by the court? If Meyer can show a prima facie case of each of those, he'll be able to do so. The real question, the prima facie case that will be hard for Meyer on the defamation claim will be to show damages stemming from the defamation. The alleged defamatory statements are that he is a racist. That's going to be an opinion statement. That's a weak claim, period. Racism, that's an opinion statement, and that's going to be very hard to... You can't factually say someone is or isn't a racist. I mean, maybe you can. They'll certainly argue that, no, he's got diverse children, and, he's not a racist, clearly, because his children are of various different races, right? Like, that would be an argument. However, you can still have an opinion that someone is a racist, even if they have different race children, okay? And that's just how it goes. The real defamatory statement claim that is of interest to me is the fact that Mark Waid made false statements about Meyer publishing the names and phone numbers of employees of comic book shops who did not want to carry his book, whereas Meyer only made available only talked about the publicly available phone numbers of the comic book shops that are available on Google, the public contact information for the shops, and the name of the people specifically making the statements involved. So I don't think those are sustainable claims or sustainable for Mark Waid. The question is, can he make a prima facie case for damages relating to that statement? Might be able to. He has said that Mark Waid's statements about him, which are false, have led to him being excluded from conventions and other things. So that is possible there, that he could make a prima facie case. It'll be up to his lawyer and other facts that they have available. I don't have access to all of those facts. So, but that's the TCPA claim that's going to come. They're going to challenge both the tortious interference and the defamation claims as specifically being within their free speech rights. And then the burden will shift back to you, boy, Zack, to go ahead and counter those things, obviously with the help of his attorney. So we'll be watching for those on the channel. That's how they will come out. I'll be very interested to see super lawyer Mark Zaid's approach to the TCPA. I'm guessing he will have nothing to do with writing it. I'm guessing lead attorney Mark Zaid, who is definitely doing all of the legal legwork and has just hired a Texas firm as co-counsel to do the filing, and because it's within the court rules, and certainly not lead attorney as listed on the case, Betsy Reeves, whose office has done all of the work so far, while Zaid sits and jerks himself off on Twitter about just how smart and cool he is, while continually getting dunked on by people who are both less qualified than him and have far less of a following than him. I'm sure he'll be right up front there, writing that TCPA claim. But when that TCPA claim comes through, I will gladly let you know, because Waid's going to lose the jurisdictional argument, 90% chance. I do think he loses the TCPA argument. I absolutely do, at least on the tortious interference. It's possible he wins it on the defamation, but I think they can make at least a prima facie case. Oh, excuse me. Of all of the elements. But I think that's how this goes. We do have 2 chats that came in. I was hoping Mr. Burch would come back, because one of these is directed to him. It was Knieger. He says, Stephen, do you sleep with your clients? I think the answer to that is not, unless my client is my wife. I'll just go ahead and say that for him. And then finally, Blue Samurai Zero says, many people comment that SJWs remind them of demonic possession. Could Waid win on the defense? The devil made me do it. No. Not without a whole lot more evidence. I mean, I guess you could technically win on the defense of anything. He could claim some sort of incompetence or insanity, but even though he is definitely incompetent and potentially insane, his incompetence or insanity, he's still able to manifest intent. And this is an interesting thing with tort law. The question is not whether or not the person knew how their actions specifically would be handled. The question is whether they intended to cause injury even within their crazy world. So if you intend to cause injury even within your crazy world of craziness, that intent is imputed into the real world. So, all right, guys, I'm really tired. It's Thanksgiving. We've been going for 2 hours on the nose here. So I'm going to go ahead and wrap up the stream. Thank you so much for joining me. Guys, I have a pop filter. I do. It's at home. I'm 1,500 miles away. The pop filter will be back on Monday. I apologize for not bringing it with me, but I only had a carry-on and I didn't want it to get shredded up. And I haven't had the opportunity to go to any store while I've been down on vacation and get another one. So I apologize. I'm trying to avoid making plosive syllables into the microphone because of that, but it will make its triumphant return on Monday when I am home. So, all right, guys. Thank you so much for joining me tonight. Really glad we could have your boy Zack on here. And finally, thank you all for hanging out with me on this wonderful holiday evening. I hope you got to spend it with friends and family. And if you did not, I hope you have some friends and family to hang out with very soon. Thank you, guys. Again, I will talk to you tomorrow. We will have one more live stream on my vacation, I believe. I have to figure out a topic. I have a couple in mind. One of them involves Alex Jones. So if you're interested in that type of stuff, let me know what you want to hear about. Other than that, you guys have a wonderful evening. Peace. You put your sock over the mic. Talk to you guys later.